Hi, here we go again on another constitutional coup video. And I just talked about this in the previous video, which I discussed about the fact we don't have any elections. Here's an astounding case that I just found, in part because of the work I'm doing on the Oakland case and the research I've been doing on that case. But other things come into play here too. And I came across a case called parte Kawato, Kawato, 317 US 69. Those of you who want an annotated copy of that, please send me an email at youwinnincourt@gmail.com on information to get my constitutional defense document packets, and I'll send you a courtesy copy of this. This is astounding. Kawato, this is 1943, so right in the middle of World War II, which shouldn't have happened. That's a video for another day. Files in the Supreme Court, and he gets issued a writ of mandate to the federal district court in the original jurisdiction of the U.S. Supreme Court, not the appellate side where 95% of the stuff goes, maybe more than that. And this is an undocumented enemy alien, or so the government maintained at the time. And apparently the Japanese government wasn't in any way involved that I've been able to find here, so he didn't have anybody behind him that would have had the ability to do this. But he gets an original writ issued there. And we can't do the same thing as lawful de jure just sanguineous state citizens for those of us who are? And if not, why not? Because in effect, a series of events that I've talked about in other videos, especially on the 14th Amendment, look that one up, have in effect made us all stateless entities. And what they think in Washington, D.C. are undocumented enemy aliens. Now, if that's the case, we can do exactly the same thing that Kawato did here and get our cases issued, because we've not ever had a day in court. And I can tell you, in my 5th decade now, I've done everything in the world over the course of these decades to get things, right before the courts, get decisions made, and it never happens. Now, the good news for me is I'm good enough at it that they know better than to go to trial and try to put me in jail. That's not going to happen. It didn't happen in South Carolina. It ain't going to happen here either. And I'm going to try to teach you people out there to get my materials and study them, especially the 5 basic documents in my trial court packet. But the other things you'll get with the entirety of what I do. You've got an 82-page brief on admission of new states. Contains almost 60 decisions of the 9 old farts in there on this subject, directly or otherwise. And it's not what this idiot defense attorney blandly told me when I interviewed him with the Oakland case, my interpretation of the law. It's anything but. And we can prove it. And that undoes the whole system. That one issue, that's the crown jewel of what I do. You understand that issue, you start off on the right foot. Trust me. So, that said, this Kawato case, and I researched some related cases with it. And this case, by the way, to make it even better, was written by Hugo L. Black. Not only in my top 10 list of justices on the court all time, but in a lot of people's. And this might well be one of the reasons for it. To write an opinion like this and say, wait just a minute here. This, by the way, the backstory is Kawato had been at the time in the United States for 40 years, came over here about 1904, and had lived here ever since. And yet, FDR's government was saying, in effect, you're an undocumented enemy alien. No right to come into our courts. If you read this case, those of you that get it, and don't know what you're reading, it might look a lot like what's happening to you when you try to get into what are our courts, and we can't get there. That's the major problem with the whole damn system, because once we do that and expose what's going on and get it on the record, one case, especially with the 9 Forks, cleans out every penal facility in the United States, because none of the courts have jurisdiction, and I don't care what happened or did not happen. But this case, you read this, it's astounding, the quotes that are in here that talk about what's going on here. And by the way, it's directly related, although I don't believe they cited this case, and Black could have cited it, called Windsor v. McVeigh, 93 U.S. 274. You read this case, where strikingly similar circumstances, because they treated Windsor as an undocumented enemy alien. They gave him notice they were going to take away some of his property by forfeiture, but they were going to have a court hearing. So he shows up, his attorney shows up, And in that era, they sometimes actually did their jobs. And the judge says, we're not going to hear you. You belong to the Confederate States of America. You're an undocumented enemy alien. See you later. Now, he goes to the 904s, and you read the decision. And I'll send you that complimentary with the request for materials too. You win in court at gmail.com. You read what they wrote. It's an eye opener about this, and the opportunity to be heard. That's the foundation of our adversarial system of government. The foundation. And everybody that's gone to Starboard and Fail and UC Berkeley knows this, and yet they do nothing about it because it threatens their interests as members of the State Bar Association. They want to maintain control of the entirety of the organs of the government, local, state, federal, you name it. And they do right now. That's what we have to get around. And I believe I have more than one way to do that. And the Oakland case has provided a lot of background for that. And I think we're going to get a decision there real soon. If we get our removal petition filed, they're not going to be able to do anything about it. But in any case, I've been learning a lot about this particular issue. I sensed it anyway, that we're in a very similar position to this. And yet I have the definitive textbook on statelessness in the United States by Catherine Seckler Hudson in 1934. Nowhere in her book does it mention the loss of citizenship and relegation to statelessness in any way remotely resembling what's happened to us with the 14th Amendment and the incorporation of the United States. If those were the goals, they would have had to have been overt. Our representatives, at the very least, would have had to voted on it. And I think the 14th Amendment would have had to have been ratified by people in conventions of the states and with full knowledge of what the hell was going on. That never happened. That's why the amendment doesn't exist. You read my brief, you're going to see it immediately. If that's out of the way, our troubles are out of the way. They can't admit it on the record. We're going to have to be able to force them to do that. And I think I'm getting close to that point now where we can. It's a tough fight. I'm on my 14th year all in here. I'm not giving up. You shouldn't either. Especially those of you that have children and grandchildren. It's your posterity here that are going to be the beneficiaries of what we do now. And I'm glad I'm able to do this. I wish I had known 50 years ago when I was in school about all I've been talking about here and more. If they would have given me one veto of Andrew Johnson of the Civil Rights Act or the Reconstruction Act, life would have been different. Coming out of high school, I'd have been doing this. They never told me, and they almost certainly never told you. All you heard about Johnson was he was the first president impeached. Like he was the worst president we ever had. And like they say in Langley, black is white. It's exactly the opposite. And he really got impeached for telling the truth. A very dangerous occupation for anybody in politics. That's not how you keep your career ongoing. And Johnson, of course, failed to do so. He was out of office and never heard of him again. But he did what he could. And by the way, followed the same policies that Lincoln had set up before he was conveniently assassinated. Interesting. I mean, it just goes on and on and on. But if you understand that undocumented enemy aliens have more access to the courts than we have, the obvious question is what the hell is going on here? Wow, it's just hard to put it into words, but trust me, you get this case, send me an email, you win in court at gmail.com, I'll whip you out this Kawato case, you read it, and you figure it out, what they said there. And I'm not sure if they understood fully the importance of what they were doing, because this is 1943, and we hadn't gotten nearly so far into what I call the National Socialist government as we have in the intervening years. But we were 13 years into the New Deal almost, and that was taking things over, and the federal government was moving to take everything over, and they succeeded in doing it for the most part, to the point now when I was sitting there in Columbia, South Carolina, we had a case in North Carolina. As far as I know, it never got into court, but the claim was made by the attorney, by this idiot transgender entity, that he had a right to select his own public bathroom. And the attorney argued that was true because taking a crap in a publicly funded bathroom affected interstate commerce. What the hell doesn't, if that's true? And that tells you right away, if the feds can do that, it can control every bodily function you have, including abortion, by the way, stored for a different day. what do you do that does not affect interstate commerce? And those of you that know the Constitution know that the Constitution is the supreme law of the land, and everything that they can do will summarily preempt anything on the state level. Now, they made a mockery of using that over the course of the years, but that's what they think. It's all interstate commerce. And only once in 80 years, and 60 years when the case was decided, U.S. v. Lopez, 514 U.S. 549, a great case to read. First and only time that I'm aware of in 80 years, and I know farts have limited the Commerce Clause powers of Congress. And even then, I think it was only 6-3, but you read this case, and the concurring opinions of Justice O'Connor and Justice Scalia, I think, both of whom indicated we've gone far astray from the original understanding of the Commerce Clause powers. And that's putting it mildly. They understood. But that's the only time, 1995, here we are a quarter of a century later, and I'm not aware of another case that's reached them on this subject. They're going to be hearing from me, and hopefully they'll be hearing from you, perhaps through me, with issues of just this type. Because if we're in territories or states, whichever, the states are prohibited by Article 3, Section 2, can't exercise admiralty jurisdiction, which is what Commerce Clause powers are. If they're in territories, then how the hell did you go from a state to a territory before we get anywhere else? And actually, the 904s have ruled in territories. Federal district courts have dual jurisdictions, one as a territorial tribunal, the other as a federal circuit court. This at a time when we had federal circuit courts, not federal circuit courts of appeal. Forget about them. Federal circuit courts, and they're going to claim they were supposedly extinguished in 1911 in the Judiciary Act. Couldn't have happened. Especially if we're going to lose the states, and now we have no concurrent jurisdiction there. We have to have it in the federal courts, or we can't invoke any rights secured by the Constitution. The net effect of that is that there's no Constitution. Do you suppose FDR or anybody like that, or even Trump today, would get up and say that? Or the 904s, if we get a case there, and say, do your sworn duty here. If we're going to say what the law is, either tell us that we're right, or tell the American people we don't have a Constitution. Those are the only two choices I leave them. And that's exactly what it is we want to do. So this whole business, I will get back to you with an update. I'm still doing some ongoing research with Kawato, and I'll get back to you. I'm going to use it in my removal petition, and we may do a removal directly to the U.S. Supreme Court, a writ of mandate, and ask them to order the court here in Oakland to file this, hear it, decide it, and set this kid free. If that's what it takes, so be it. At long last, we're going to have a way to do it, and once we get it on the record, you can follow me and do the same thing. That said, remember to like my videos, tell your friends, subscribe, and send emails to me at uwinnincourt@gmail.com for more information. Thank you.